Welcome to Open Meetings 101, Notices and Agenda. Suzanne Spears, please make note of my email as well as my cell phone number for future reference. Let's look at some perspective on the Open Meetings Act before we actually get started. It was originally crafted in 1977 and it was one paragraph. It included two goals. One was to encourage, the second was to facilitate. Both of those are still in place and embedded as the mission of the current Open Meetings Act. In fact, you can say that the current Open Meetings Act is Oklahoma's basic public policy with respect to both participating in government processes and looking towards solving governmental problems. In other words, to encourage and facilitate a local citizen is what we are trying to accomplish with this statute of open meeting. One tall order, in other words. And I think it's that this point of view is how we need to adjust our own sites and examine how to interact with the public from the very beginning point, which is basically your notice and your agenda. So what we want to do today is look at just one section of this law, Section 311A and B, found in Title 25. Now the statute breaks apart the notice and the agenda, so that's what I think we want to do. On a regular basis, we always look at the agenda and we realize that it actually includes the information that the notice contains. But we forget that it's not the same the other way around. All right, so let's take a comparison. If it's spring and you're getting a lot of wedding invitations, prior to that wedding invitation, you usually get something called a save the date. We can look at the save the date as a precursor to the wedding. And in fact, when you get a save the date notice, you learn that there's a wedding in the works. That wedding needs to be put on your calendar so you can keep that particular date free. Now, the save the date lets you know whose wedding it is, the date of the wedding, and usually the time and the place. And so therefore you know at some future point in time you will also receive an actual wedding invitation that gives you all the details. In other words, the person who sent you the original save the date is actually encouraging and facilitating their wedding guest. In some ways, they're helping to ensure the creation of an informed wedding party. Exactly your job in county government with notices and agenda. Notice of all regular board meetings must be filed with the county clerk's office by December 15th of the prior year. This filing of notice is a list of all the regular meetings to occur in the upcoming year. It is well in advance of the meetings actually occurring, and so therefore, because they're regular board meetings, you can plan ahead. When you have a change to either the date, the time, or the location of a regular board meeting during the year, you must meet an additional 10-day posting requirement. Let's back up. For a special meeting, a notice must be posted 48 hours before the special meeting is scheduled to occur. So again, a notice for a regular board meeting is actually December 15th of the prior year. A special meeting is 48 hours. In both of these situations, the time specifications, either December 10th or the 10-day prior to a change, as well as the 48-hour requirement, there are no restrictions to how the time is counted. When we discuss the 24-hour posting requirement for agendas later, there is a stipulation. That 24 hours always excludes Saturdays, Sundays, and holidays. Now, a notice is to let the public know a meeting is scheduled to occur. It tells the public who is having the meeting and where it will actually take place. So that simple act of posting the notice puts the public on notice. Now, we also have to remember that the notice must be posted in prominent public view. You can't require binoculars to see this. So the location has to have easy access. It needs to be convenient. It needs to be visible before and after business hours. Now, the posting place requirements is not verbatim in the statute. It is actually detailed in an opinion that was written by the Attorney General in 1997. That opinion is still current and necessary now as it was in the late 90s. All right, so now then let's look at how is an agenda different than a notice. Now the notice was our save the date equivalent of the wedding invitation information, and it gave details that were limited to date, time, and place. So what we have now in the agenda is that the agenda actually flushes out the details and all the particulars. In fact, it not only identifies the items of business the public body is going to consider, it also specifies if there's any action that will be taken. If you have forgotten to identify that possible action will be taken on an item, let's look at maybe you forgot and left off a vote indicator when you were going to discuss buying that new tractor, then your public body is not in the position to take action. And it's very important that you do not do the public's business without proper specifics in your agenda. Also remember that votes must be publicly cast and they must be publicly recorded. If a vote is going to be taken on any item, the agenda must reflect that possibility. Now, as a side note, once the agenda is posted, you have basically said that agenda has been approved. A posted agenda equals an approved agenda within the statute of Oklahoma. Nothing can be added to this meeting's agenda except new business, which is certainly defined within the statute. In fact, that definition is found in 311A9. New business is any matter not known about or which could not have been reasonably foreseen prior to the time of posting. In that case, an addition can be made to your agenda. But always remember, a posted agenda is the same thing as an approved agenda. And what we want to do is break apart the difference between a regular scheduled meeting and a special meeting because it has to do with the amount of time requiring posting requirements. A regular scheduled meeting simply conducts the regular business of the public body. In order to meet the criteria for a regular scheduled meeting, the public body would have filed a listing of the time, date, and place, the notice, of each of their meetings for the coming year, and this would have been filed by December 15th of the prior year. For county government, this document is filed with the county clerk of their respective county. Now remember, in order to file this yearly notice, there had to be an action item, which would have been listed on the agenda, typically an early December meeting, and a vote would have been taken as required by the board. For example, let's say the ambulance board meets the first Tuesday of every month. The agenda item on the first December meeting, or possibly that the November meeting, would be discussion and possible vote on annual meetings, date, time, and location for the following year. And this agenda item would have been putting the public on notice that the regular meeting scheduling for the next year was to be discussed and acted upon. Now, if the public body's meetings in the past had been in an inaccessible location, perhaps the back of the police station where the dispatcher is located, then the public was put on notice that they had an opportunity to bring their concern to the discussion. Once the board approved by vote the location and dates for their meetings for the coming year, the details for the year of the meetings would be sent to the county clerk for filing. Anyone then can access the calendar for a full year. Since the time, date, and place has been made public now, the only thing left to make public is the agenda. The agenda then is posted at least 24 hours before the meeting, which, remember, 24 hours excludes Saturdays and Sundays and holidays. Remember, action must be indicated on an agenda in order for action to take place. If you're going to vote on an issue, let the public know. A special meeting is a little bit different. A special meeting is a meeting for something outside of the typical business conducted at your regular board meeting. An example could be awarding a bid following a bond election, if the timing is such that to do so would make sound business sense. Another example may be the appointment of an employee following an untimely vacancy. The overriding intent of a special meeting is that the action could be taken care of during a regular board meeting, but there is simply a timing issue. The action of the special meeting is not addressing an emergency, as an emergency by its very nature would require a quicker response. Since this meeting is outside the listing of the year's calendar filing with the county clerk of all the regular board meetings, then it requires a little more time in the posting stage. In other words, remember, posting requirements are in place to aid public participation. The public has to be put on notice that action possibly will occur that affects them, especially if it is affecting their pocketbook. A public board must give notice 48 hours before the scheduled special meeting. That notice once again indicates date, time, and place. Now, agendas always require 24 hours notice. Again, remember, 24 hours excludes Saturdays, Sundays, and holidays. The law requires the agenda to be posted basically with the same posting requirements for public viewing as the notice. A good practice is always to post the agenda as quickly as possible. This gives the public adequate notice for participation. If it can be posted at the same time as the notice requirements, that's even better. It allows the public more time to be aware of the new meeting, and if the public board can conduct its business in a transparent way, there's no room for secrets. Not even room for being accused of secrets. Remember to always take minutes during a special meeting and list approved minutes of the special board meeting as an action item on the regular agenda for the following regular board meeting. That allows you to have the minutes approved and recorded. In other words, on that following regular board meeting, there will be 2 sets of minutes for approval, the prior regular board meeting as well as the special meeting. Executive sessions get to be a little bit tricky. Now, executive sessions are required at times. But remember that the underlying intent of the open meetings law is transparency of government. Well, executive sessions are exactly the opposite. You take care of business behind closed doors. So if the door of your meeting is shut, there are a couple things you need to be aware of prior to shutting the door. First and foremost, the public needs to know the door is going to be shut, and they need to know the reason for the closing of the door. Secondly, the public needs to know that whatever decision a board makes, that decision was made when the door was open and it was in front of the public. It's simply the responsible board member's goal. All votes must be publicly cast, and all decisions must be publicly made. Now, in order to go into executive session, you first have to confirm that the item you want to discuss behind closed doors is an item that you can, by law, discuss privately. Once you've identified the statute reference for your particular situation, that reference and an accompanying description must be listed clearly on the agenda. In this situation of B1, whereby personnel matters are going to be discussed, the Attorney General opinion that occurred in 1997, number 61, states, agenda items to discuss personnel matters for which an executive session is proposed must identify either the position or the individual salaried employee who is the subject of the discussion. Identification by name is necessary unless the position held by the person is so unique as to allow adequate identification. Always remember that. It's also a good reminder to look at the Attorney General opinions for guidance and correct interpretation when the statute itself needs some fleshing out. A couple of other things. Minutes must be kept during executive session. They don't require approval, and they certainly don't require a vote. However, they must be kept and sealed. Let's look at the agenda itself on the crafting end. Agendas really are a tool for action. If you look at agendas over time, they actually become your diary or the record that you've kept of the things you've dealt with, the items you've managed. They reflect the seasonality of your business, and they also give you a good perspective of what type of board you actually are. Are you a board that works towards consensus? Or are you a board that gets a lot of discussion and puts things out for a task force? They give you the cultural workings of your board. What you may innocently think of as a one-time meeting schedule is actually your very first educational tool that you can use to grow that concerned and involved citizen. If your job is to encourage and facilitate, your first item of action is your agenda. At the very basic level, your agenda is your agreement with your citizens to get done the business of your public body. When you put it in terms of the bigger perspective, it actually gains a little importance, and it's the importance that is due. It's easy to ignore this first step or to simply treat it as a byproduct or a catch-all. And when that occurs, you set yourself up for surprises to occur during the meeting. Attention to detail takes out the room for emotion. when you take out the room for emotion, it keeps surprises to a minimum. And it also gives you the opportunity to move your agenda forward and therefore your organization forward, rather than being stalled or disabled simply due to disgruntlement. One of the basic questions I get a lot is, who is in charge of crafting the agenda? So let's think about it. Who do people think are in charge of crafting the agenda? And equally important, what is the process that is currently in place? Is this a process by which legitimate constituent concerns can be dealt with in an open meeting format? Or is it necessary to deal with them in an open meeting format? Do your citizens know and understand the process of open meetings? Do you have something simple that's written up, a policy or flyer that steps you through the process? Or do you have a method, which is some counties use just a fill-in-the-blank petition request to appear on the open meetings? Whenever I look at who is in charge of crafting an agenda, the only references that are given are within the county commissioners, Title 19, Chapter 10, Section 327, which basically says at the first meeting of each year, county commissioners will elect one of their number to be the chairman. When a definition is not given in statute, you go and you look as to what is the typical definition in place. Chairman is typically referred to as the presiding officer, and Webster's dictionary actually defines to preside is to occupy the place of authority. Someone must be in charge of crafting the agenda. The process must be understood by not only the members of the board in order to participate well, and the staff to also shore that participation up, but it must be very transparent to the citizens of your county in order that they understand the workings of your board. When you're crafting the agenda, I kind of use my grandmother as my filter. My grandmother was one smart cookie. She was in her late 80s. She never missed voting in an election. And so I use her. If I think my grandmother could understand my agenda, if my grandmother could picture participating in the process of open meetings, then I had done a good job in getting the job done. If I did not think she could, then I'd have to go back to the drawing board and start again. So for me, answering the question of who is in charge on crafting the agenda, I have to look and ask myself, would my grandmother understand that? So let's begin. Let's kind of break it out. How's it done right now as far as putting an agenda together in your county? How are items actually placed on the agenda? Is that approach working? If it works well, how do you know if it's working well? Once we know how our agendas are actually put together, and we have to also come to take the responsibility that our agendas are actually our action plan. You need to sit down just a minute then and say, what do your past agendas say about your public body? What's your primary action of your public body? What direction is your public body headed? And is that direction and do those agendas tell the true picture? Statutes do not tell you who is in charge of making the agenda. They do not tell you how to run your meeting and whether or not you should adopt a particular form of parliamentary procedure. Instead, the Oklahoma statute allows the public body itself to craft the way that is best for them within statutory guidelines provided and Attorney General opinions given. It's in that way that the public body's culture of policies and procedures, when used consistently, acts as your educational environment for your citizens. A couple of different things that we want to look at, because you have to craft the agenda prior to posting it. So one thing that I found very useful is supporting documents for the agenda items for your board members. You need to be clear about asking yourself if you have adequately prepared your board members to be good participants in the meeting. Do they understand the background to the items that you're discussing and possibly acting on? If so, did you include an explanatory memo? Who prepared that background information? Who receives the memo to the board? And how is that information distributed? One thing that must be kept in mind at all time is a ruling that took place in 2007. This was a court ruling. It determined at that point that pre-meeting packets were subject to the Open Records Act. It allowed for redaction of any confidential information contained in the documents. The ruling is in line with the provisions of the Open Record Act in Title 51, Section 24A9, that allows personal notes and personally created material to be kept confidential prior to taking action, but upon action must be fully disclosed. So as you're putting together a packet or you're looking at distributing documents to help your board members be fully informed regarding items on the agenda, do so knowing that it would be information that would be distributed if necessary or requested as an open record. I want to go back to agendas just as another reiteration of my grandmother filter. But in 2008, once again, the issue came up regarding the technicalities and the wording of an agenda. But you must be able to state in plain language the purpose of the meeting, as well as knowing that the meeting agenda must be able to be comprehended to a person of ordinary education level, and that in the statute is usually a 6th to 8th grade determination of education. So a good thing to do is read back over what you've written. Use the grandmother filter when you read it, and ensure that what you said is actually what you wanted to say, and that even your grandmother would agree. So again, reread your agenda. Do you know the topic that's being discussed? Do you understand that there could be possible action or outcome? Do you know what the options are of the possible outcome? And basically, ask the question, would my grandmother understand? In closing, critically important, what is posted is approved. Notice tells the date, time, and place. The agenda lists every item, as well as indicating what item will have action or possible action. Your job is to encourage and facilitate participation of your citizens. Your job is also to get the job done. Thanks.